Welcome to today's webinar, Waiver of Subrogation Explained, what every business owner and contractor must know. If you've ever reviewed a construction contract, commercial lease, service agreement, or vendor contract, you've probably seen the phrase waiver of subrogation. For many people, it's one of the most misunderstood provisions in risk management and commercial insurance. Some sign the agreement without reading it. Others assume it's simply legal language that doesn't really matter. In reality, a waiver of subrogation can significantly impact how claims are handled and how responsibility is allocated after a loss. Today we'll explain what subrogation means, how waivers work, why they're commonly required, what business owners should know before agreeing to them. Let's start with the foundation. What is subrogation? Before we can understand a waiver of subrogation, we first need to understand subrogation itself. Subrogation is a legal right that allows an insurance company to pursue reimbursement from another party after paying a claim. Here's a simple example. A contractor accidentally damages a building during work. The owner's insurance company pays for repairs. Insurance company finds contractor responsible. Insurer may pursue the contractor or contractor's insurer for recovery. This recovery process is called subrogation. Insurance companies use subrogation to recover losses, help control claim costs. What is a waiver of subrogation? A waiver of subrogation limits or eliminates an insurance company's ability to seek recovery against another party after paying a claim. In simple terms, the insurance company agrees not to go after the other party for reimbursement. Waiver established through contract requirements and supported by insurance policy endorsements. Purpose: reduces disputes and litigation among business partners. Instead of fighting over responsibility after a loss, the parties agree in advance that certain claims will stay with their own insurance carriers. This keeps the process smoother and relationships intact. Why are waivers of subrogation common? Reduce lawsuits between project participants, create predictability when claims occur, preserve business relationships, support broader contractual risk transfer strategies. Especially valuable in industries with close collaboration. By setting expectations before work begins, parties avoid conflict after a loss. Common industries that use waivers: construction contracts, commercial leases, property management agreements, vendor agreements, service contracts, real estate development projects. Often, waivers work with other risk transfer tools. These provisions create a comprehensive risk management framework: indemnification clauses, hold harmless agreements, additional insured endorsements, insurance requirements. How waivers of subrogation work. Example: reduces conflict and keeps relationship intact. Property owner hires contractor for office renovation. Both carry insurance and contract includes waiver of subrogation. Accident causes property damage. Owner's insurer pays but doesn't recover from contractor due to waiver. Common misconceptions. Waiver of subrogation does not eliminate insurance coverage. Coverage and claim payments still exist. Waiver affects recovery rights after payment, not coverage itself. Another misconception: contract language alone doesn't automatically create the waiver. Insurance policy must also support waiver via endorsement. Always review endorsements. Common mistakes businesses make. Mistake number 1, not reviewing contract requirements. Many sign agreements without understanding obligations. Always review insurance obligations carefully. Mistake number 2, assuming coverage automatically includes a waiver. Not all policies provide waivers by default. Some require specific endorsements. Verification is critical. Mistake number 3, failing to coordinate contracts and insurance. Contract and insurance policy should align. If not, coverage disputes may arise. Mistake number 4, ignoring documentation. If waiver is required, keep documentation showing compliance. Proper record keeping is key to risk management. Best practices for business owners. Review contract language carefully. Consult your insurance advisor. Verify endorsement requirements. Maintain supporting documentation. Conduct periodic compliance reviews. Coordinate risk management procedures across departments. The goal is to eliminate surprises after a claim occurs. Review waiver and insurance requirements before projects begin. How waivers fit into contractual risk transfer. Waivers of subrogation are just one piece of a larger strategy, usually combined with indemnification provisions, endorsements, insurance requirements, certificate of insurance verification. Effective risk management programs combine these tools for multiple layers of protection, help reduce liability, improve claims, and strengthen business relationships. Conclusion and key takeaways. Subrogation lets insurers recover after paying a claim. A waiver of subrogation limits those recovery rights. Purpose: reduce litigation, improve predictability, support risk transfer. Key reminders: understand contract requirements, verify policy and endorsements, maintain documentation, coordinate insurance and contract obligations, review compliance regularly. A properly implemented waiver of subrogation can help protect business relationships and strengthen your overall risk management strategy. Thank you for joining today's webinar. For more information on business insurance, contractual risk transfer, and commercial risk management, visit www.montridgeinsurance.com. We appreciate your time and look forward to seeing you in the next